with Harry Stokes from Galveston ISD. Sorry about the bell. And we are excited to have you join us today for our Lunch and Learn with the Galveston and Brazoria counties. We are partnering today with Allison Skalberg from Consolidated Planning Group. We are so excited to be able to be with her again. And I'll go ahead and turn the time over to her for some housekeeping and additional information. Thank you.
Thanks so much, Jan. Nice to see you again. And thanks, Terry, for joining us today. For the housekeeping items, your cameras and your microphones are muted, so we can't see you and we can't hear you other than our presenters today. But we do know you're there and we're glad you're here. We would like you to put your questions in the chat box today, and you can just do it throughout the presentation. I'm going to be monitoring the chat box, and I'll read those questions out to Debbie, and we're going to answer just as many as we can. We're going from 12 to 1 today, so if you're planning your schedule, we will be finished by 1 o'clock. Today's webinar is being recorded as well, and you also are going to get a copy of today's slides, so you don't have to write every single thing down that is said today. You are going to get those slides. So happy to be here. Again, Allison Skalberg, Consolidated Planning Group. We are a holistic special needs planning firm. We partner with a lot of organizations all across the state of Texas, providing webinar and education, advocacy for special needs families, families that may have kids that are transitioning, families that may have adults with disabilities or loved ones in their life. So today we are excited to be partnering with Debbie I hope I say it, Diaz, right?
Yes,
is that right? Okay,
right.
Good. And she is going to be talking to us about the options that are available through Galveston as it relates to guardianship. And, guardianship is one of those things that's kind of a buzzword in our community that we're hearing about all the time. We're thinking about, we're knowing about what are the alternatives to guardianship. What is a supported decision-making agreement anyway? There's so many things that we have questions about on a pretty regular basis. So I am going to turn it over to Debbie, and she is going to get started kind of talking to us about guardianship and the process. So thank you, Debbie, for joining us.
Sure. Thanks for having me. Good afternoon. My name is Debbie Diaz. I'm the court investigator for probate court here in Galveston. So we service all of Galveston County. So just real quick, pretty much everything that I'm going to cover mainly pertains to Galveston County, our process, but I've got some information for Brazoria and Harris County, but the procedure is the same if you take the step to do guardianship. So that the procedure is the same, but maybe how to get you started in the process might be a little bit different. So I guess we want to start with the first slide. Basically, Texas has 18 statutory probate courts. We have one in Galveston. Harris County has 4. Different counties have statutory probate courts. Some have just county courts that do probate information, so it's a little bit different. But one of them is here in Galveston County. Next slide. So, and just to kind of give you a background of what we do in probate court, we of course we probate wills, we determine heirship, we do mental health commitments. We do guardianships, which is the main thing that we're here to talk about today. And then we do ancillary cases if related to one of the above. And an example of that would be like if someone's under a guardianship and they file for divorce, we could bring the divorce case in here as opposed to it being in family court. So just kind of a little addition on that. What is guardianship? That's mainly what we're here to talk about today. Next slide. Basically, what we do in guardianships is for a person that we consider to be an incapacitated person. And the definition by the Texas Estates Code is someone who's unable to provide food, clothing, or shelter for himself or herself, care for their own personal, their own physical health, or manage their own financial affairs.
I just have a quick question on that. So these 3 bullet points that we have on the screen, are these or is it any one of the 3, or do they all 3 need to be met for the criteria?
It could be any one of the 3. Guardianships are done case by case situation. I mean, sometimes we have people, it's only a physical disability, and sometimes they might need a little bit of assistance, and guardianships can be tailored to what we need as far as what rights we need to take away, or what, how, if we need to do like can't think of the word right now, I lost it, a partial guardianship as opposed to a total guardianship. So it just depends. Some of these people, some of the folks that come in here, they might not be able to manage their own financial affairs. We may not have to do guardianship. We may be able to set up like a management trust or something like that. So there will be ways to avoid guardianship. But to answer your question, no, it doesn't have to be all three. It can be one or two or just one, just depending on the rest of the circumstances. Basically, what guarding the person does, once you're appointed guardian of the person, you determine where a person lives, you make all their medical decisions, you ensure that they have food and clothing, make sure they, if they're in school, make sure they attend school. And these types of situations where it's parents becoming guardians of their adult child with a disability, you're going to basically continue doing what you're doing now as their parent, except once they turn 18, legally they're considered an adult. So you have to either get letters of guardianship or do an alternative to guardianship so you can continue making these decisions for them. Guardian of the estate, I'm just going to kind of touch on that. It's really not going to apply in these type of situations that we're talking about now. If you're appointed as someone's guardian of their estate, you're going to handle all their financial aspects. It could be someone has money from an inheritance, a personal injury case, a medical malpractice suit, something like that. But if you're appointed guardian of their estate, then you're also going to be responsible for managing their finances and reporting to the probate court how their funds are being spent. So the legal process for guardianship of a person, this is going to be the same throughout any court, Brazoria, Harris, Galveston County. You have to have some medical documentation that the person has a disability or what their disability is. And what we use here is a determination of intellectual and developmental disability, which is performed by James Simpson, is the psychologist at the Gulf Coast Center. We'll accept those. And there's another form that is pretty universal in the state of Texas. It's a certificate of capacity assessment where their doctor would fill it out and let us know what their incapacity is. We'll accept either one. Some courts will only take the certificate of medical examination, but the code allows us to take either one. So we can do either or. And usually in that process, I contact the Gulf Coast Center to see if they have an assessment. If they have it, I get that information. If they don't, then I meet with the families and give them the form to have their doctor fill out. So that kind of, I guess, leads into the next slide. I am the court investigator here for Galveston County. And whenever a case comes to me, all of the cases in Galveston County have to come through me. I go out and I meet with the family and kind of go over some of the things that we're going to talk about here. I write a report and I turn it into the judge. So next slide.
Any of these forms that you were referring to, are they on the website? Is this something that a family could download from the website if they wanted to?
The capacity assessment is definitely on the website. That's on there. The assessment comes directly from the Gulf Coast Center. It's something that's their form, they fill it out. So, but the capacity assessment is definitely on our website. So this is where we're going to kind of have a little bit of differences between the three counties for guardianships. Whenever a guardianship is filed, an attorney has to file it. Guardianship is one of those things that you can't file yourself. You can't represent yourself in court unless you're an attorney, because you're going to be representing somebody else's interest. So you have to be an attorney to be able to do that in the courtroom. So you have a couple of different options. You could always go out and hire your own attorney. But when you're doing guardianship, it has to be a probate attorney who's certified in guardianship. It can't just be any attorney. They have to have that certification. Otherwise, you've wasted money filing, because we can't have a hearing in our court unless that attorney is certified to do guardianship. So what we do here in Galveston County is there's funding, and all the courts have this funding, and money's put in there from every time you file a case. There's filing fees, there's fees for the judge's signature, it goes on and on. So those funds build up year after year. Judge Sullivan, who is the judge that I work for, has decided to use those funds in these type of cases where it's families that are applying to be guardians of their adult child who has a disability. So what we do here is we appoint what's called a guardian ad litem. And that's the person, their role is to do what's in the best interest of proposed ward, is what we call the individual whose guardianship is being sought after. And so they will file the application normally on the parent's behalf, unless, there's no parents, it might be another relative, but they file that application on their behalf. And then an attorney ad litem is appointed and they represent what the proposed ward wants. So if the proposed ward says, no, I don't want my mom and dad, or no, I don't want my aunt to be my guardian, that's what they have to come to court and say. In Galveston County, we pay for those attorneys. So we're trying to, we feel like the parents have a lot of things that they have to worry about and they have to pay for. So if this is one thing that we could help them with, make it a little bit easier, that's what we do here. In Brazoria County, what you have to do is you have to go to Lone Star Legal Aid and you have to, try to get them to file your application for guardianship. If they don't, you'll get a letter saying that you are denied or what, they're not going to do it. You then take that to Brazoria County clerk's office, and then the judge decides whether they want to appoint an attorney or not. In Harris County, you have to hire an attorney. You have to hire an attorney to do the guardianship.
So we have a quick question.
Okay.
It says, does one have to be a resident of Galveston County to access those services, or do you simply have to file in Galveston County?
You have to live in Galveston County, or you have, the person who we're doing a guardianship for has to reside in Galveston County. So sometimes we have situations where the adult with disabilities might reside in Galveston County in a group home, but the parents live someplace else. The fact that the proposed ward is in Galveston County, we can file the guardianship here. But we only have jurisdiction for Galveston County. So that's why we have to have the proposed ward in Galveston County.
Because it's come up before, I do want to ask you, because I think a lot of people have basically heard that Galveston County has this big program that basically if you live in Galveston County, that guardianship is free. And so while there's some truth to that, there is some misconception. And could you clarify, can you just kind of clarify that a little bit better for the folks that are on here today?
Basically, it's not like it's a free program. We have this funding. When that funding goes away or gets depleted, then we won't be able to do that. But at this point, while that funding is there, that's what my Judge Sullivan, has decided to use that money for. The other courts, all the courts also have this funding, and the judge gets to choose how they use it. And so some judges choose to use it for indigent programs, which could sometimes apply to guardianship, but could also to apply to just any other type of case where the person is indigent. So it's just a matter of our judge has decided to handle it this way, and that's how we do it. And once the money's gone, it's gone. But I don't think that's going to happen anytime soon.
So for clarity, the program in Galveston is not just for the indigent. It is available for Galveston County residents that
Right.
need guardianship.
Right. But more specifically for adults who have a disability and their parents are applying to be their guardians.
So a couple additional questions. Says, so the law dictates you file guardianship in the county of the proposed ward's resident. Is that correct?
Yes, that's correct.
Okay. And then two people are asking if you have any insight as it relates to Fort Bend County, where you could seek assistance or financial assistance for guardianship.
I didn't really check with Fort Bend County because I just was told Brazoria and Harris, but I do know that Fort Bend County does not have a court investigator. They don't have someone like me on staff there. Fort Bend doesn't have a statutory probate court. So their county courts their county courts handle their guardianship. So I'm not exactly sure what their process is, but I'm going to guess it's probably about the same, that you either have to hire an attorney or some type of Lone Star Legal Aid to start that process for you.
Yeah, I was going to say there's definitely Lone Star Legal Aid, and I think there's one other legal aid group in Fort Bend County, so you can check those out as well. And of course, we have referrals for attorneys in Fort Bend County that definitely handle handle guardianship. And so we have another question. Okay, so then somebody said, what about Harris County and Brazoria? So let's go ahead and hit Harris County and Brazoria County as well, because we've got people from all different counties on here today.
Like I said, Brazoria County, you have to go to Lone Star Legal Aid. If you're not able to afford the attorney to file the application for guardianship, they require you to go to Lone Star Legal Aid. If they want, sometimes they'll take cases. I know here in Galveston, they don't really do a whole lot of guardianships. I think probably because they know that we'll do it, but they also are overwhelmed with Hurricane Harvey cases and stuff like that. So I know that they're not doing it. But in Brazoria County, you go to Lone Star Legal Aid. If they decline to file your case, they're going to give you something in writing to say that they're not going to proceed with your case. You then have to take that to the clerk's office in Brazoria County. And then I guess they give it to the judge, and the judge decides, yes, we feel like we need to appoint an attorney in this case, or no, we don't. Because it's going to be they'll base it on the parent's income. What makes us different, I think, is we don't base what we do on the parent's income. We're basing it on the proposed ward's income. And that's how we're able to use this funding. In Harris County, you have to hire an attorney. I talked to the investigator this morning, and you have to hire an attorney. But Harris County has a lot more resources than we do in a lot of these smaller counties. There's also Lone Star Legal Aid there. They have Volunteer Lawyers Association. You have Thurgood Marshall Law School, South Texas Law School. So they have like volunteer or some type of organizations in there that can help with filing the guardianship applications.
So we've always heard that that one could start the process beginning with the paperwork and stuff 6 months prior to the ward turning 18 years old. Can you confirm if that's accurate?
Yes, that's correct. The estates code, which is what we follow, you can only start the guardianship process 6 months before they turn 18. You can't start it any sooner. And it doesn't take us 6 months to do it. Normally, everything goes right, but it doesn't take that long. So usually
Gotcha.
I tell people about 3 months before they turn 18, but some people want to get it started, so they're not worried about it. It's in place, but 6 months is the earliest that we can start that process.
And then, furthermore, if your child is post age 18 or they're 21 or 22 and you didn't get around to this, it doesn't mean that you still can't go through that process, correct?
Right, correct. Not at all. You can start anytime. I mean, anybody that's 18 and beyond, I'm doing guardianship for people that are in their 30s and 40s that the parents have gone all this time being their parents and they've never run into any problems. And then all of a sudden they do. They're at a doctor's office and the doctor says, sorry, you can't make decisions for them. And then, they're in a panic. We still do guardianships in the same way. We still pay the attorneys. It's not any different.
We've got other counties that are coming up. And what I would like to say is if you're in any of the other counties that we haven't talked about, I think a good place. So number one, Googling legal aid near me, legal aid services near me. And that Lone Star Legal is one. There's chapters all over the place. And if you're not finding anything, the other place that you could contact, because they have list of information, the ARC near you or your county ARC may also be able to provide where are the places that have assisted or services for the indigent for guardianship. So I think those are two good places to go. Someone says, I was told that there is a waiting list for getting guardianship. Can you clarify what does that mean?
We do not have a waiting list. I've never heard of a waiting list, but there's not a waiting list for us. Now, sometimes might take me a minute to get back with you if you're because I'm the only person that does this for all of Galveston County. So, I'm in court, I'm doing visits, I got to get my paperwork done sometimes, but there's not a waiting list. Normally what happens is the families contact me, and I have this is further on in the slideshow, but I get the information we need and then we get the process going. There's not a waiting list. Nobody's ever put on a waiting list. And we try to, if I meet with the family and they're going to be 18 in a couple of weeks, obviously we can't get everything done by then because there is a process that we have to go through. But, you know, we try to get them through as quickly as we can.
Thank
Is that
you.
Okay. So that this next slide talks about the court hearing. We have to have a hearing with everybody present, but that's kind of a little bit misleading. The proposed ward does not have to be here. The parents or parent, you know, it doesn't have to be both parents. If the parents are together, we normally recommend that both parents file to be guardian. But if it's just one parent, either way is fine. The parents have to be here. The proposed ward does not have to be here. So we don't have to take them out of school. We don't have to disrupt their day, but you're certainly welcome to bring them. That second attorney that we appoint, the attorney ad litem, is going to represent your child in the courtroom, and they're going to speak on their behalf as to what they, you know, if the guardianship is in their best interest. And then these type of cases are typically what we would consider to be a non-confrontational hearing. We also do guardianships for elderly people that have like dementia and Parkinson, and sometimes they have children that are arguing over who should be guardian. But typically with these kind of cases, it's a 10 or 15-minute hearing and we're done. So
Someone said, if the process begins before the proposed ward is 18, can one attorney be hired for both parties?
I don't think I understand that question. So tell me one more time.
If they start this process prior to the individual turning 18, can they have one attorney be hired for both parties? I think maybe they're speaking of the attorney ad litem, but the attorney ad litem happens no matter what, correct?
Right. That's a completely different role. So we have parents that are applying for guardianship, that one attorney would represent them. They would file the application for guardianship. And anytime we have an application for guardianship filed, we have to appoint an attorney ad litem to represent the proposed ward. That person is entitled to have their own representation. And it makes more sense in the cases where it's elderly, because sometimes these folks don't need a guardianship. So they need an attorney to be able to step in and say, you know, no, we're going to contest this and we're going to have an argument. But yes, so it has to be two separate attorneys. If that's what the question is, someone has to file the application, an attorney, and another attorney has to represent the proposed ward.
The one other question that we had is, like, your program in Galveston County, does it also include wills and trusts and other documents, or is it just basically for guardianship?
It's only for guardianship, but the attorneys that we appoint, since in order to be able to do guardianships, you have to be certified. So all of our attorneys are certified. We appoint the same ones that you're going to go out and hire. They can assist you. And I always tell, when I go out and meet with families, I always tell them, you know, if you have questions about special needs trust, wills, all that kind of stuff, you're welcome to talk to these attorneys. Later on, you might have to pay them for those services, but a lot of them might, you know, point you in the right direction or say, do this. I mean, they're all really good attorneys. And so I always tell people, if you have questions, and a lot of times when we come in court, the judge will say, you know, talk to your attorney about it, and they'll talk, maybe get you somewhere going, and it might end up that you retain them to do those services for you. But no, we don't pay for that right now.
One more question. If you have two proposed wards, can they be both in the same court hearing, or would they need to be separated?
Like if they're siblings?
Correct.
No, we would do that at the same time. It makes more sense. It's more cost efficient. We would appoint the same attorney to file the application and the same attorney to be the attorney ad litem for both of them. It just, because it's just more cost efficient that way to do it, unless one turns 18 and then 3 years later, the other one turns 18. We couldn't do it that way. But if they're both 18 or over 18, we would do them at the same time.
Great question. Thanks for asking that one. I don't actually, of all the guardianship questions that we've had in the past, I've actually never had anyone say that. This person indicates that they're twins, so they would be at the same time.
Yes, definitely. Definitely. Yeah. It makes more sense. It's just it's easier, more concise. And then we've kind of talked about this too, the legal fees, we're going to pay for them. But you also still may choose to hire your own attorney So, and again, we base it upon the assets of the proposed board, which is usually always going to be either zero, Social Security, or they might, some people already have ABLE account set up, or money in the Arc of Texas, or a special needs trust, but that doesn't affect, well, we're not considering that to be an asset to make them. Now, if somebody had money from a lawsuit or something like that, that's different. That's going to be considered an asset, and we wouldn't be able to appoint an attorney.
So you mentioned earlier that guardianship is by county. So if you already had guardianship in one county and then you move to a new county, what do you do to find out what the procedures are for that specific county that you've moved to? What do you need to do?
Usually, once somebody's been appointed as guardian, there's a couple of things that they're required to do. And one thing is to do an annual report, and that's how you renew your letters every year. In the state of Texas, your guardianship letters expire every year. There's some states that it's permanent. There's some states that it's every 2 years or whatever, but Texas, it's every year. So when you fill in that form, you're putting address, doctor's names, that kind of stuff. We are supposed to look, I see all those that come through here. And if your address is no longer in Galveston County, we start the process to transfer it. And all the courts do that. We are not supposed to keep cases on our docket that aren't Galveston County cases or Harris County cases or whatever. So if someone comes to me, or some people might call me or on their annual report, like I said, new address, then we send it to that county. We send a waiver to the guardians to let them know that we're transferring it and have you sign it. And then our clerk's office sends all that information to the new county, and they should contact you. That's what we do here. If another case is transferred here, we get all the information. I forward it on to our coordinator. We set it for a hearing. We set it for a hearing here just to have you come in. And so we can explain our process here, because you might be coming from a county without, that you might be just a county court that's doing it. And so we require here, we have to do statutory visits where we send out a court visitor once a year. And that's because we're a statutory probate court. And so we tell people that, and plus that way they can come and meet me, meet the judge, so they'll know who they're dealing with. And it's real simple. That's like a 5-minute hearing just to come in so we can tell you, okay, now you're in Galveston County, these are your report dates, and then we'll just go from there. It's a pretty easy process. That's within Texas. If you move to another state, it takes a few more steps to get that process going.
Someone said, I'm sorry.
That's okay.
Someone said, what fund could one ward have at the Arc of Texas? And that is the Master Pool Special Needs Trust that she's referring to with the Arc of Texas. A lot of the families that we serve have special needs trusts. They have their own, but there is a Master Pool Trust that you can read about and learn about that is through the Arc of Texas. So that is what she is referring to there. And it's a whole nother rabbit trail. We have entire presentations for special needs trust, first party and third party, and ABLE accounts, which are all places that you can have money that won't count against you for SSI and Medicaid. But that's really a whole nother topic. But we definitely do have webinars on those complete topics on our YouTube channel. We'll provide that at the end. I think it's in the chat box as well.
So this is I guess this slide needs to be fixed because it kind of skips around. It talks about why you need a guardianship, which we've kind of already covered. The law states that once a person obtains the age of 18, they're considered an adult. Legally, they're an adult. So legally, medical attention may be denied unless there's an emergency. If there's an emergency, of course, for doctors, they have to treat that emergency. But we always use like the dentist as an example. If you go to the dentist and they say they need to pull a tooth, most of the time that's not an emergency situation. Sometimes it could be, but you might have an individual that can say no, that they don't want it pulled. And if they're 18, then they're not going to pull it. You have to have that legal guardianship to be able to make that decision for them. And then we always include participation in a group home, ARD meetings, and discussions for medical treatment. Different types of procedures might also be denied. I've had incidents in group homes where once the individual is 18, there's no guardianship in place. The parents want to move them because, their clothes are being stolen, whatever. There's several, And when they try to move them, they won't let them because they don't have guardianship and that person is their own guardian. If they say they want to stay there, then you can't move them. So
let's talk about that for a second, Debbie, because this is something that comes up in my practice all the time. Because, it is a slippery slope on whether or not a family wants to take the rights away of their kids. So whether it's partial guardianship, full guardianship, power of attorney, healthcare power of attorney, what have you. Can we talk about what a good general rule of thumb is? Like, is it an IQ score? Is it the capacity to understand? And let's say, because what we do see is that we see a lot of kids with various diagnoses that at 18, they're definitely not there yet. But as parents, we're still hopeful and optimistic they are going to get there. It's definitely going to be delayed by several years. So when we have families like that, what do we do?
Well, I mean, that's one of the parts of when I go out and talk to families, because we talk about these alternatives to guardianship. And I know sometimes one of the big things that comes up is driving, because that is one of the rights that we take away with the guardianship is the right to drive. I do know that unless we have a doctor saying that the person can drive, we're going to definitely take that right away, because it was actually a Harris County case, but now we have it. A gentleman was allowed to keep his right to drive, and he had an accident and killed somebody. And so I know the judges don't want that liability. So what I've talked to with the FIFA, when I go out, and this is what we talk about, you know your child better than I do. You know what they're capable of, what they're not capable of. If we do put that in the guardianship that we're taking away their right to drive, and 5 years down the line or 2 years down the line, a doctor says they believe that they can drive, we can always put that right back. A guardianship is permanent, but we can always come back and change things. If, we just have to have the medical evidence to support that. The judge and I neither one of us are doctors. But if you have a doctor that now says they can vote or they can drive a car or whatever, then certainly we can come back in and look at that because we don't want to keep somebody from accomplishing things, to doing things that they're able to do. We did a guardianship for a young lady who has made remarkable improvements, and she enrolled in college and she's in a job program. And part of the job program was that she couldn't have a guardian of her person, certain things. So there were certain things that we put back in there. So she was able to participate in that job training program. So there are ways to, I don't want to say get around it, but to tailor it to fit the need of the person that we're working with. But what I always like to talk to people about when I go and see them is, you have to think about other things besides just getting in the car, starting it. What if there's an accident? What happens if the police come? Are they going to panic? Are they going to drive off? Do they know to stay? Do they know, so there's a lot of things to think about for that aspect of it, for the driving. So that is a big topic. I know that a lot of folks still want to drive, but I always, that's their decision. But I can tell you, if you come to court here and the doctor says they can't drive, we're going to take that right away. So
let's talk about questionable powers of attorney when parents are having their adult child sign a power of attorney, and perhaps the child has zero capacity to understand what they're signing. Can we talk about that?
Sure. I can tell you that Judge Sullivan considers those powers of attorneys to be invalid, because what you're having someone sign is a contract that lists out a whole bunch of things. It has legal language in it. I have a power of attorney, and I can honestly say that I probably don't understand what every part of it means. I just know that I want to have one. She considers those to be invalid, and it just depends on where you used it. If you're going to have an issue with it, I don't. The doctor might feel like, oh, I know that this person is severely incapacitated. They didn't understand what they were signing, so I'm not going to accept this. So that would be one of the issues that you would run into. In a situation like this, where it's parents doing it for their child, you might not have the the battling siblings or something like that to say, oh, no, that's not valid. I didn't believe they signed it, that kind of thing. The other thing too, that I want to let you know about a power of attorney is, like I talked about, the guardianship is permanent. We have had situations where people improve and we can remove it. If we have the medical evidence, I have, some young adults that are improving, and as long as the medical comes back and says they don't need the guardianship or they can do these things, we're happy to go in and take it away. We don't want to have everybody under a guardianship. But the point I was making in that is, if you do a power of attorney or a supported decision-making agreement, which is another alternative to guardianship, if your child encounters, let's say, some not so nice people, and they say, oh, I can do that for you instead of your mom or your dad, and they change it, or the supported decision-making agreement gets tore up, that's what happens. I mean, then whoever they name as their supporter, or whoever they give a name as their agent under the power of attorney, takes that away. You can't then come back in and say, oh, well, they didn't have the capacity to sign that.
Uh-oh, I think she's frozen for a second. Can you hear us okay, Debbie? She'll be back in a second. I think that, so there was a question in the chat box, and I think she was just kind of hitting on that a person can, in fact, the word can, in fact, get their rights back. So if they need a guardianship or partial guardianship, that the word definitely can get their rights back. And in a moment, I apologize. I think we're having some.
I'm back on. I don't know if she's back on.
Okay.
Yeah.
Yep. Can you hear?
Can
Can
you
you
hear
hear me? Okay.
I can hear
you
you.
all hear me? Can you hear Terry Stokes?
Yes.
Yes.
Okay, I'm getting a signal that says my internet is unstable here in Galveston. So we've had several interruptions. So I don't know if Debbie's in Galveston or what, but we have been having some problems.
Yeah, I'm in Galveston.
Okay.
Okay. Let me try to stop this share and try it again. I apologize for that. We don't always have technical difficulties. We actually rarely do. Okay. So can you hear me okay? And can you see the slides?
Yes, I can.
Yes, I can.
Okay.
I can.
Okay. So we don't see Debbie yet. So what I was saying is that the word can get their rights, the rights back. There's Debbie. You're back. Can you hear us okay, Debbie?
Yes. Yes.
Okay. So that was one of the questions. And one thing that, Debbie, you were just hitting on, and I think was a very valid thing. So it's not even somebody just hoodooing your child as far as getting them to tear up the supported decision-making or the power of attorney. Some of our kids have oppositional defiance, or they're kind of adversarial at times and things like that. And so we have definitely seen families that went the power of attorney route, and it didn't go well. So, but that's
Right.
part of what you guys do, is doing that assessment of that situation, kind of to see what makes the most sense. But just know that it's not forever and ever and amen, that the person can get their rights back. And there truly is a such thing as partial guardianship. So if we're kind of there, but maybe your child needs help with medical decisions, or you want them to be able to drive. I mean, so there basically there's options for that partial guardianship, right, Debbie?
Yes, definitely. Yes. And the supported decision-making agreement too I suggest or recommend those all the time. And a lot of times what I tell, especially if your adult is high functioning, a lot of times what I tell the families is, if you want to try this first and see how that works, that's fine. Just because you try to use supported decision-making agreement, or if you try to go the power of attorney route, that doesn't mean you can't do guardianship. We can still do it for you if you find out that that's not working, if that's not helping your needs. So.
Sure. And your slide that you have on the screen now, that's kind of just what we were talking about a moment ago with special needs trust and ABLE account. And as Jan put in the chat box, we do have some upcoming things scheduled to talk about those things. And we also have things on our YouTube channel. But the bottom line is your kids inheriting money. If they're getting SSI and Medicaid, or if they're on a Medicaid waiver or anything like that, anytime Medicaid is involved or SSI is involved, how they get money matters. And if they get basically anything over $2,000, it could basically mess everything up. That's it in a nutshell. So it's important to have money in the right buckets, and those right buckets are an able account or a special needs trust that won't be counted against them. So again, check out the YouTube channel for that. But it is an important thing to have, definitely have on your radar. So Debbie, this is your contact information, and they are welcome to reach out to you and kind of with their questions as it relates to Galveston. Is that right?
Of course, yes. I'd rather,
And if they reach out and they and like an appointment needs to be scheduled, what is that timeline? Is that a couple of weeks, a couple of months, or how does that look?
it could be in the next day. I mean, it's just depends on what's going on. If, I try to work with your schedule as much as I can. I mean, I try not to work nights and weekends, but sometimes I have to do it. I try to make it as easy as I possibly can. So.
Do you have I don't know if you have the ability to talk a little bit more about what is supported decision making? Can you talk a little bit about that?
Of course. I mean, I can tell you it's basically a 1-page form. The second page is for signatures. And what it is your child, your individual is naming you as their supporter to support them in making decisions. So it has like a checkbox of the things that they want you to be able to help make decisions on, like medical, school, employment. There's a couple of things on there. And then there's a box for other. That's like you could put Medicaid or Social Security. I'm not really clear on how they are going to accept it with Medicaid and Social Security. I've heard so many different things and so many different reasonings at Social Security office about sometimes they don't even care whether you have guardianship or not. So basically what it does is, you fill that out, and then the last page, you either have 2 signatures or you have it notarized. And it's just basically a piece of paper that you have to show these different entities that your person has named you as their supporter. And so it should allow you to be able to speak to those individuals, like to the doctor, to the school, and help support your person. Now, if you have a supported decision-making agreement, and say, for example, you're in a doctor's office, if at any point your child says, I want my mom or dad to leave, or no, you have to go. That's, it's as long as they are willing to give you that ability to support them. That's basically what that is, to make decisions. And it's an alternative to guardianship because you don't have to come to court, doesn't take the rights away, that kind of thing. So it's just something, and it's quick because you just sign it and get done with it, and that's it. You don't have to go through the court process. So I don't know if that helps.
And we recommend that those supported decision-making agreements are not standalone, that you actually have a power of attorney and healthcare power of attorney along with a supported decision-making agreement is probably a best practice. Someone said, can you please talk a little bit more about the partial guardianship? And I would say that we see a lot of families that are kind of in that category. Maybe they have their child may have high functioning autism, maybe they're ADHD, maybe they're a little bit delayed, but they don't have severely low IQ or intellectual disabilities. They're just not there yet. So let's talk more about that.
Sure. Well, we talk about doing a partial guardianship, but there's the rights that we take away when we do a guardianship is the right to drive, the right to vote, the right to make decisions regarding residence, the right to make decisions regarding marriage, and the right to purchase a firearm. That's real big in Texas. We have to have a firearm. So we can leave some of those rights in there. The driving one is a very touchy subject, but like if you feel like your child's able to vote, then we won't take that right to vote away. That's what we would consider to be a partial guardianship. And some of the language in there is changed for, we don't say they're totally incapacitated. We say they're partially incapacitated to make some decisions. But me personally, when I go out and talk to different families, but again, you know your child better than I do. when we talk about the decisions, marriage and determining your own place of residence, I always tell people because I'm a parent, I would rather leave that in there, because it doesn't mean that they can't get married, doesn't mean that they can't go get their own apartment or whatever. It just means that you have that final say. You help make that decision. If you feel like it's appropriate for your young person to be in an apartment or a group home or something else, you make that decision. And then with you holding the guardianship, you're able to decide if it's time for them to move or go someplace else or things like that. Same thing with marriage. If you decide that there's someone that's a good individual, that you think it would be a good thing for them to marry, they can certainly do that, but you have the final say as to whether that happens or not. And the only reason that I even, not necessarily advocate for that, but discuss that, I've had a lot of cases where I have individuals that are high functioning and they get on the internet and they meet somebody on the internet and they take off, or they go meet them someplace. And when your child's 18 and they're not under a guardianship and you call the police and you say, my daughter, my son ran away, they're not considered a runaway. They're an adult. They have that right to make that decision if that's what they choose. So I kind of just, try to give families both sides of it, so you'll know kind of what you're walking into, because that happens sometimes. I've actually worked a few cases where that happens, where they've met someone or been involved. I had a young man who's high functioning autistic, met somebody on the internet, and he was in Mississippi. He got in a truck and took off, went to Mississippi, and his family didn't have guardianship, and the police were not very helpful because he chose to go there on his own. So I'd like to err on the side of caution, if that makes sense.
Couple of things on the chat box. One person said, can you tell us more about the Medicaid waivers? At the end of the presentation and in the chat box, we've got our YouTube channel, and we actually have a whole presentation for Medicaid waivers. But the bottom line is there is a waiting list in Texas. It's very long. Anywhere from 15 to 17 years. You do want to get your child on the list. There are multiple waivers, but that presentation on YouTube will tell you what the waivers are, how to get on the list, how to check your status of the list and everything like that. And you can reach out to us directly. We can help you with that. Another person said, basically, what if I die? So basically the question is if I have guardianship of my child, can I have a successor guardian? Or if I die, is my child going to become a ward of the state?
Yeah, I hear that a lot about your child being the ward of the state. What we do here, and it should be across the board anywhere, we're always going to look for a family member first. But you can address that in your will. If you have will, that would be a good reason for doing some estate planning. You could name who you want to be your successor guardian. So that would be the first place that, that we would look. Just so you know too, I know I didn't bring this up, but in order to be someone's guardian, we run background checks on you. We have to make sure that you don't have a criminal history or that you don't owe money to the proposed ward. So say, for example, if you had a relative that's who you wanted to be their guardian, we're going to try to honor that. But if they have a criminal history, we're not going to appoint them. What we do here is, that's a part of my job too, is if someone passes away and I find out about it, usually someone makes a phone call and it's usually the person who wants to be guardian. Then we do the background check. And if they work, then we appoint that person as a guardian. But I try to reach out to family members if there's no one, see what's going on. Because the other thing we take into account is there might be family members, but they might not have anything to do with this person, and they haven't for 30 or 40 years. And that may not be the way to go. But what we have here in Galveston County is our county contracts with an agency called Friends for Life. And I know Harris County has a guardianship referral program where they are certified guardians. And that's who we would appoint to become your son or daughter's guardian if there was nobody else. So then they would then place them, probably group home would be the option, or personal care home, or depending on what the situation were, if they're able to stay home, that they would do that. But ward of the state is, it really is a term I wish they would kind of get rid of, but there are some individuals that are like at Austin State Hospital and things like that. And that's just for people who really aren't able to function in society. Like their disability is so severe, or their behavior is so uncontrollable that they have to be in a different area. And you have to go to court for that. It's a process. People just don't say, oh, they're a ward of the state and they send them off somewhere. It's a court process that before someone can be placed somewhere like that. So I hope that helps. Is that?
Yes, that's very good. And a lot of those come up, and I'm going to bring one up that comes up almost every time we ever do a guardianship webinar. So what if I'm divorced? What if I have a ex-spouse that is not in agreement that guardianship is needed? Or what if the child's other biological parent is out of the country? Those are two things that usually come up every guardianship meeting we have.
Okay, so it just depends on, so if the parents are married, of course, we want to do co-guardianships. If the parents are divorced, we don't really like to do co-guardianships because sometimes, they're divorced for a reason. So getting them to communicate, to do an annual report and all that kind of stuff is a little bit difficult. But if the parents are divorced and they get along and they're able to make decisions that are in the person's best interest, if they're working together, we will still do co-guardians with the divorced parents. It's not our favorite thing to do, but we will still do it as long as we know that the two parents are able to still communicate with each other and make decisions for the person. If one parent is opposed to it, we base ours on the assessment from the doctor and the need for it. So if we have the assessment from the Gulf Coast Center or from the person's doctor saying that they need a guardian, that's what we're going to go. We're going to proceed with that. The other parent would then have to hire an attorney because we're not going to appoint someone in that situation. We're not going to appoint someone in because then it would become a contested situation. The parent who contacted me and we started the process already, they're going to have an attorney appointed, but the parent who is contesting it is going to have to go and hire an attorney. And sometimes I find that that's enough to get, they'll back off and they'll do it. Usually when we talk to, what I've found a lot in my cases is the parent that's contesting it is contesting it because they think they're going to have to pay child support because the person's under guardianship, and that's not true. It's not how it works. But yeah, so we can do that. In the parent out of the country, it just depends. If they're wanting to be co-guardian, they would have to be here for the court hearing. And then if they leave the country, that's fine. But if they're out of the country, when we start the guardianship process, it makes it a little bit difficult to serve them because there is a process that we need to follow. But it's really case by case situation. I have cases where one parent leaves shortly after the child's born. And so if they haven't had any contact with their child in 18 years, I'm gonna be honest with you, I don't make the effort to find them. So I kind of get around that a little bit because we put whereabouts unknown, and the code just requires us to, if the whereabouts are unknown, then we can't find them. So we're not gonna do it. So I really haven't had that situation come up though, where somebody's out of the country. But if they want to be co-guardians, then they would have to be here to do that process and then they could leave. But if it's just a matter of they're not participating or they, they're not, like I said, I'm not going to waste time and money to try and hunt them down if that's not.
For sure. Some of the things that we've got up on the screen here are just things that should be on your special needs planning radar. We do have webinars on every single one of these topics, but since we've been talking about guardianship, kind of turning 18, some of these things, one important thing that I do want to hit on, child support being redirected to a first party special needs trust when they turn 18. In the state of Texas, a lot of families have child support that continues post age 18 for their kids that have disabilities. And if you're planning on applying for SSI and Medicaid when your child turns 18, that child support needs to be redirected to a first party special needs trust, or it's going to be counted against the child themselves as income. So it will affect their ability to get benefits. It may cause them not to get benefits at all, depending on the amount. And that is something, it's not a do it yourself. I mean, you can work with the spouse that's paying, the ex-spouse that is paying child support and say, hey, we need to get this written up. A judge has to sign off on it, basically, so it doesn't have to be a big fight. If everybody agrees it's the same amount of money and we're going to redirect it to a first party special needs trust, the judge signs off on it. And then the money is directed to a first party special needs trust. But that's a big deal. And people not knowing that, it causes their child not to be eligible for SSI and Medicaid. So that's definitely should be on your radar. Let me see, we're wrapping up here with time. Does medical letter for guardianship have to be dated close to the ward's birthday as opposed to a childhood letter that began school services for the child?
Not necessarily close to their birthday. The assessment that we get from the Gulf Coast Center, that we have to have our hearing within 24 months of the date of that assessment. So usually what Mr. Simpson does is he does like from the initial assessment that they did, and then he does an update to make it current. So we have the 24 months to get it done. With the letter from the doctor, and you can go on our website and look at that and see, but there's a box, I think it's on the 3rd page, and it talks about IQ, disability, that kind of stuff. That gives us a 24-month period for that form. If you take your form just to the doctor and have them fill it out, say, they fill it out when your child's 16, it's not going to be valid anymore. Though the assessment from the doctor, the guardianship application has to be filed within 120 days of that date. So unless they fill out that box in the middle, and I have trouble sometimes getting the doctor to do that, but when I go see the parents, I usually have that part highlighted. Make sure your doctor fills this out, because then we have 24 months to get the hearing set. And trust me, it doesn't take that long, but it gives us that time frame. Whereas if you just went and they filled it out, say they dated it March of 2022, but your child's not going to be 18 until December of 2022, that's going to time out. We're not going to be able to use that. Because it expires in 120 days. And an application for guardianship has to be filed before that 120 days. So if you're going to use that form, then I would suggest using it closer to their birthday, a couple months before or whatever, unless they fill out that middle part. If you're confident your doctor's going to fill it out, then you can wait a little bit longer, but that's the only time frame. It's 120 days.
Thank you. Thank you for sharing that. Thank you everyone for being here today. Wow, what great questions you guys ask. I love it when the chat box is busy, because if you've got that question, somebody else has got the question too. So I mentioned the YouTube channel a couple of times, basically all the topics on what should be on your special needs planning radar, whether it's waivers, special needs trust, guardianship, you name it, SSI, Medicaid, big one. We've got webinars on all of those topics. If you've signed up for today and you're here today, then you'll get an email once a month. Don't worry, we're very busy and we won't spam you, but once a month, you will get an email with all of our webinars for the whole month, so you can jump on any one that you would like. But you can subscribe to the YouTube channel for free and listen till your heart is desired. We are nationally certified as Social Security advisors. So if you've got questions on SSI and Medicaid, you need help with that process, we can help you there. We're also members of the Special Needs Planning Academy. Our consultations are always free. So if you have personalized situations or questions that you definitely want to ask in a public forum, certainly reach out. You can use that QR code and it'll take to a calendar where you can schedule a one-on-one appointment with us. So I would just like to personally thank you, Debbie, for being here with us and telling us about this program. I've heard rumblings about it, and so now we know. I didn't have all of the details. I had heard about the Galveston program. It had come up several times. So thank you for that. And Jan and Edith and all of our other partners that are here with us from the various ISDs, thank you for joining us today. And we certainly look forward to partnering with all of you again. I got 12:59, so we're right on time. Thanks, everyone, and I hope you guys have a great weekend.
Thank you. Thank
Bye
you for
now.
having. Bye-bye.